It doesn't matter. Listen, I'm not asking you if you like what their offer is.
I know.
Okay. I don't care if you like it or not. It doesn't matter. I just need to know if you understand what it is. In cause number 26 DCCR, excuse me, 0005, you're charged with the state jail felony offense of evading arrest or detention with previous convictions. And that's from June 25th of 2025. Your indictment alleges you were previously convicted of evading arrest or detention January 12th of 2015. Then the indictment goes further to allege that you were previously convicted of burglary of a habitation December 22nd of 1993. After that was final, you were convicted of burglary of a habitation November 7th of 1994. And then after that, you were convicted of possession of cocaine with intent to deliver, a first-degree felony, January 30th of 2009. And then after that was final, you were convicted of indecency with a child by exposure, a third-degree felony, September 21st of 2017. What all of that means is that if you go to trial and you're found guilty in this current case, and if at least 2 of those prior offenses are true, that you were convicted, your punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand? Do you understand that?
The way he's talking is it's going to be a bit worse. I mean, I don't understand.
What do you not understand?
You understand the range of punishment is 2 to 20 years, correct?
I ain't gonna make it that long anyways.
Look, I just need to know if you understand that if you go to trial and you're found guilty, what the consequences could be. And the consequences could be a minimum punishment of 2 years up to 20 years. Do you understand that?
Yes, I understand that part.
Okay. So the state has made an offer. I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker that shows that the offer they've made, if you wanted to enter a plea of guilty, is for an 8-year term in prison. You have every right to reject that and have a jury determine if you're guilty or not and what your punishment is. I just want to make sure you understand what your options are if you want to plead guilty and what your consequences could be if you go to trial. Do you understand all of that?
Well, I better take the.
Listen, just listen to my questions. Do you understand that? What your options are and what your consequences could be. I just need to know if you understand it. It doesn't matter. Listen, I'm not asking you if you like what their offer is.
I know.
Okay. I don't care if you like it or not. It doesn't matter. I just need to know if you understand what it is. Do you understand?
Yes.
And so go
I'm
ahead.
sorry, Judge, if I may, the state, based on the facts of the offense itself, the state would be more than willing to cap that at 8 years. He received 15 last time on that evading. So we were actually even going to come to the court with seeking your permission for that 8 based on the facts of the offense. But with everything that he has in his past, the state would certainly be willing, based on the underlying facts, to cap it if they make any difference.
Have y'all talked about that?
No, we haven't talked about a cap.
Why don't y'all go back and talk
Okay.
about it and I'll hold it for a minute. Thank you.
On page 4, the postal sorry for the day with the screaming. Apparently, she had like 15 cases, and there's one not fixed. And they don't.
Brandon Benton.
Yes, ma'am.
Okay.
Put it with the.
Oh, gotcha. We are resetting Brandon Bonta. Mr. Lewis, you have Ephraim Dinkin.
Yes, ma'am.
Good morning. Are you Ephraim Dinkin?
Yes.
And Mr. Lewis, will your client waive the formal reading of the motion?
He would.
Mr. Dinkin, and cause number 19-32080, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation August 12th of 2019 for aggravated assault, and that was a 5-year deferred probation. Is that correct?
Yes.
This motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation office for the months of September and October of 2023. And is that true or not true?
Yes.
True or not true? Thank you. Count 2 alleges that you failed to never become intoxicated or under the influence of any intoxicating substance, and that you tested positive for alcohol June 19th, July 12th, and August 28th of 2023. And is that true or not true?
True.
Three alleges that you failed to provide verification of entering and successfully completing the anger management program as ordered. Is that true or not true? Count 4 alleges that you are behind in your court assessed fees. Is that true or not true? And then count 5 alleges that you failed to complete the drug rehabilitation orientation program or the DROP program. Is that true or not true? Did you enter your pleas of true to counts 1 through 5 freely and voluntarily? Did you plead true, but did anybody force you to plead true to those counts? Okay. Did you plead true because they're actually true?
True.
Okay. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 10 years in prison. And so as long as I give you 10 years or less, you understand that you're waiving any right to appeal, correct? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Dinkin is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case for sentencing, get the probation department to do an updated report, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis, and he'll present it to me on your behalf when we come back. All right? See you back at sentencing. You can go back with the bailiff. What, I have a notation that there's new cases coming. Are those? Okay.
Yes, ma'am.
April Smith.
She's writing the CDC.
Okay, that's fine, because I think she'll probably need to get her over here first for fingerprints. Yeah.
Thought about y'all last night. Did y'all feel the boom? Never felt it.
I never felt it. Okay, let's see. This is. I don't. We've got April Smith coming. Oh, there it is. Just popped up as soon as I said it, of course. Good morning. Are you April Smith? And Mr. Lewis, will your client waive the formal reading of the motion?
She does, Judge.
So it's just open.
It is, Judge, and just to update the court, it's my understanding that Ms. Smith is going to plead not true to counts 1 and 2. Frankly, I don't blame her. I have reached out multiple times today to detectives to ask them to bring those new cases. I believe I even did so in May, if I'm correct, and I still don't have them. So I don't intend to proceed on them. We're just going to go open to the court on the full range of punishment, with the understanding that if for some reason those cases are brought in, I don't intend to proceed on this.
Okay. All right, ma'am, or Mr. Lewis, will she waive the formal reading of the motion?
She does, Judge.
Ms. Smith, in clause number 19, 33472, I have a motion to revoke your community supervision. This shows that you were placed on probation August 3rd of 2020 for the offense of theft of property with previous convictions. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct? Yes. And then it alleges that you violated your probation. Count 1 alleges that you committed the new offense of theft of property with previous convictions May 1st of 2025 in Jefferson County. And is that true or not true? Count 2 alleges that you committed the new offense of possession of a controlled substance, penalty group 1, May 1st of 2025 in Jefferson County. And is that true or not true? Count 3 alleges that you failed to immediately report to the probation officer your arrest on May 1st of 2025. And is that true or not true?
True.
Count 4 alleges that you possessed a drug, methamphetamine, on May 1st, 2025 in violation of your order. Is that true or not true? Count 5 alleges that you were at a location other than your residence at approximately 1:29 a.m. on May 1st of 2025. And is that true or not true? And then count 6 alleges that you're behind in your court assessed fees as of May 19th, 2025 in the amount of $1,713.16. Is that true or not true? Did you enter your pleas of true to counts 3, 5, and 6 freely and voluntarily? And because those counts are actually true. I have some documents here on the tablet that have your signature on them that the state's marked as exhibit number 1. Y'all have marked off that this is a plea bargain, but it's really not. So I'm going to make that change because.
The only reason I did that is because we had the agreement.
Oh,
the new
No,
case.
it's just fine.
Okay, so there is an
Right,
agreement,
right,
actually.
There was actually.
Thank you, Mr. Lewis.
And Judge, I'm sorry, I misspoke earlier. The offense dates are in May. We checked after our last setting in January.
Right.
And asked them to file them and they still.
Okay.
Yesterday.
Okay, thank you. So the agreement is that the state is willing to not go forward, or if they do at this time receive those cases, not pursue them. And that's part of that plea agreement, which means no matter what I do within the range of punishment, which is up to 2 years in the state jail prison, you're waiving any right to appeal. You understand? State tenders number 1.
No objection, Judge.
It's admitted. Any evidence that Ms. Smith is not competent?
No,
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 5, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I'm going to reset your case for sentencing so the probation department can do an updated report. It'll just give me more information about you, your case, what's been going on, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis. He'll present it to me on your behalf when we come back. Okay? See you back at sentencing.
thanks.
Crystal Julian, sentencing, Mr. Lewis.
Yes, ma'am.
Can you hear me okay like this?
Yes.
And will your client waive the formal reading of the indictment?
You will.
Mr. Cogdill, I have to go through that indictment again, even though I already did. In cause number 26, DCCR 0005, you are charged with the state jail felony offense of evading arrest or detention with previous convictions from June 25th of 2025. The indictment alleges you were previously convicted of evading arrest or detention January 12th of 2015. It further alleges that you were convicted of burglary of a habitation, first-degree felony, December 22nd of 1993. After that was final, you were convicted of burglary of a habitation, a first-degree felony, November 7th of 1994. That's enough for a second, if that's okay.
Yes, Judge.
How do you plead to that charge?
Hey, please, guilty?
Guilty.
And are those prior convictions true?
Yes.
Are you pleading guilty and true freely and voluntarily?
Yes.
And did you plead guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Stuff you signed, I explained to you.
Yes.
Do you understand those documents that you signed with Mr. Parker?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal? So as long as, and the agreement is for a cap of 8 years in prison, which means you're leaving your punishment up to me. And as long as I give you 8 years or less, you cannot change your mind and appeal later. Do you understand?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
All right. I have to ask everyone that. State tenders number one.
Objection.
It's admitted. Is there any evidence that Mr. Cogdill's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we will come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Parker and he will present it to me on your behalf when we come back. All right. I'll see you back at sentencing. You can go back with the bailiff.
Thank you. You can tell me.
Miss Holmes, you have a Brianne Williams.
Yes, sure. That one, we may not, well, you can read yours.
Brianne Williams.
Oh, her. Good morning.
Good morning.
Rand, it's not, it's contained on here.
Miss French, this is Brianne Williams. It was a TRN and now there's a new thing that's popping up about fees and yes, I love that. Good morning. Are you Brianne Deshawn Williams? And this is 18-30512. Miss Williams has a motion to revoke her probation. What is the announcement?
Your Honor, the district attorney's office is showing she has a case received. It's a 2024 offense date, but it's been received. And it appears she had a previous hearing back in 2024, which I think that offense may have been addressed, but it's just now getting to the DA's office to possibly be indicted.
Okay.
Based on the dates, I would agree with Ms. Holmes that the 11/19/24 admin hearing addressed that.
Okay.
But there have been delays with the lab. So I'm not surprised that it's just coming around, but it is received and the state would like to have an opportunity to review that once indicted.
All right. So we'll just do one normal reset. That way, obviously, if there's another case, you can get it all taken care of at the same time. Ms. Holmes will get all of that information from Ms. French and she'll be out there to visit with you, go over what your options are. And then we'll see where we are at that next court date. Okay. All right. Okay. Go back to the bailiff.
Thank you.
I'm going to wait. Dan Whitsitt. Good morning. Are you Dan Whitsitt?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor. Or it's a.
I'm sorry, the motion.
Yeah.
Yes, hold on. Let me get that pulled up. Let me get it pulled up real quick. Okay, Mr. Whitsitt, in cause number 24, DCCR 0198, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for the third-degree felony offense of injury to a child, elderly, or disabled individual, and that was a 3-year deferred probation that's been extended for 2 years. Is that correct? The motion alleges you violated your probation. Count 1 alleges that you failed to successfully complete the safety program and the aftercare, and that you were removed from it on December 18th of 2025. And is that true or not true?
It's true.
Count 2 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
And then count 3 alleges that you're behind in your court assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Whitsitt is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find that you're mentally competent to understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty, and at this time, find you guilty of the third-degree felony offense of injury to a child, elderly, or disabled individual. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff. Not real sure. I mean, it's set for sentencing, so I'm very confused about what all that meant.
What are you talking about?
Yeah. And we've had her come every single week. You don't get to just write a letter the day of court and say,
And file it after.
and there's a bug. Yeah, I'm not crazy. Did you see it? Thank you.
I've seen it.
I know. Right. That Luke pulled up for us that day, right? Yeah.
Oh my gosh, it is.
Good morning. You're John Lamel.
Yes, ma'am.
So, Mr. Lamel, I just wanted to visit with you, and so we can hopefully get your case moving forward. I know Mr. Adams has had some issues and has been unable to come to court. He filed a motion to withdraw as your attorney. Do you have any objection to that?
I don't know what you're talking about, but
He wants to withdraw and not be your attorney.
yeah.
Are you okay with that?
Yes, ma'am.
Okay.
They wasn't coming.
Right. And so here's what we can do. I can, because you're in custody, I can appoint an attorney today who can start working on your case. Do you want me to do that? Or do you think that you or your family have that money to try to hire someone else?
No, ma'am, you can give me a.
Okay. I will appoint someone today. I will let that attorney know that you've been coming and we've been having some issues and you're just sitting and waiting. And so hopefully they'll get up to speed real quick and we can see what we can get done with your case. Okay.
Thank you so much.
No problem, sir. You can go back with the bailiff. So if you want to print out that order, I'll sign it. I mean, it's a state jail felony MTRP. It's.
You can do it. I'll rather eat somebody else. He wanted to change.
What did I do?
Oh, wow, that's. Okay. It's just strong.
That was maybe, yeah, on top of the right.
And we think that Mr. Burbank will still be able to maybe come over for that bond hearing. We're just gonna kind of hold it until they're finished with closing argument next door. And so let's see, Mark Phillips, Ms. Holmes.
I'll give an motion and you can do it, they do it inside.
And I checked the first allegation. It says a Orange County case. I did check with North County. They said the case has not been filed. They said it's in review.
Okay. All right, so are you Mark Phillips? Mr. Phillips, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. And will your client waive the formal reading of the motion?
Yes, Your Honor.
Mr. Phillips, in clause number 21-36585, I have a motion to revoke your community supervision. Shows that you were placed on probation September 13th of 2021 for the third-degree felony offense of unlawful possession of a firearm by a felon. And that was a 10-year term in prison that was probated for 5 years. Is that correct? It alleges that you violated your probation. Count one alleges that you committed the new offense of assault family violence in Orange County on October 3rd of 2025. And is that true or not true? Count two alleges that you provided a urine sample August 13th, September 10th, and October 13th of 2025 that tested positive for marijuana. Is that true or not true?
True.
Count three alleges that you admitted to your Orange County probation officer that you used marijuana on or about August 27th of 2025. Is that true or not true?
True.
Count four alleges that you provided a urine sample November 6th of 2025 that tested positive for marijuana. And is that true or not true?
True.
Count five alleges that you admitted to the use of alcohol on August 27th of 2025 to your probation officer. Is that true or not true?
True.
And then count six alleges that you failed to prove the attendance of AANA meetings as directed by the substance abuse evaluation. Is that true or not true? So did you enter your pleas of true to counts 2, 3, 4, 5, and 6 freely and voluntarily? And because those counts are actually true. All right, then I'm going to find that you entered your pleas of true to counts 2 through 6 freely and voluntarily, find sufficient evidence to revoke your probation. However, I'm going to reset your case for sentencing, get the probation department to do an updated report that'll give me more information about what's been going on, maybe get some more information about that count one, the assault case, if the state intends to bring any evidence with regard to that. Well, I would think an 11 o'clock hearing would be enough.
Should be true.
Okay, so we'll set it at 11 o'clock for a hearing on sentencing. All right, go back with the bailiff.
Again.
Oh, sir, she needs your fingerprint, please. Daniel Pierce.
That's a dismissal, Your Honor. That's all, Your Honor.
Oh, got it. Signing that. He's free to go back.
Dismissal here.
Sorry, I didn't see that earlier, y'all. You're taking him back a while back. Kaylin Thornton.
Into the lesser.
Thank you, ma'am. This is Mr. Coleman's Kaylin Thornton. Good morning, sir. Are you Kaylin Thornton? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
The state's elected to proceed on the lesser included. Instead of the aggravated promotion of prostitution, the state's proceeding on a promotion of prostitution under 4303 of the penal code.
4303
of the penal code. It makes it a third degree as opposed to the first degree that the aggravated promotion of prostitution is.
Thank you. And will he waive the formal reading of the indictment as?
Yes, Your Honor.
All right, so Mr. Thornton, in cause number 26 DCCR 0220, the state's elected to proceed on the lesser included offense of a third degree felony promotion of prostitution from November 15th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation, including remaining away from the Northridge Manor Apartments at 4155 Maida Road in Beaumont. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Thornton's not
No,
competent?
Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentence. Based on the nature of that plea agreement, Mr. Coleman, what's the state's position with regard to a bond pending or bond reduction pending pre-sentence report?
The defendant shows to be a 25-year-old with no criminal history. However, there are some circumstances related to the underlying offense. I don't know if the court is. There was some violence alleged with regard to the underlying offense. Just for the court's information, we would defer to the court on that, but I just want to make the court fully aware of kind of the.
And Your Honor, we are asking if the court would consider a reduction. Mr. Thornton has no intention of returning to that property. He will.
Where would you be living when you're released, Mr. Thornton?
18 Avenue B.
That's in Beaumont.
Yes, ma'am.
So what I'm going to do pending sentencing based on the nature of your plea agreement, Mr. Thornton, is reduce your bond in your case to $2,500. If you make that bond, at least pending sentencing, I'm going to order that you wear a GPS monitoring device. That'll make sure that you're following all of the rules. You're not going anywhere near Maida, the apartments, is it Northridge Manor?
Yes, ma'am.
So don't go anywhere near those. And if you do everything you're supposed to between now and sentencing, then I'm not necessarily saying you'll have to wear that while you're on probation or for very long. But if you make that bond while the case is pending, I want to make sure that you're following all of those rules. It's very important if you make that bond, a couple of things, in addition to getting that GPS and staying away from the Northridge apartments. You're going to get some documentation today from probation. If you are released soon, then the very first thing you do is go to probation so they can do that pre-sentence report. If you don't go and don't follow through with those appointments, then you run the risk of me not accepting the plea agreement. Things could be worse. Do you understand? Also, if you are arrested for anything between now and when you come back for sentencing, you run the risk of me not accepting the plea agreement. Okay? All right. You can go back with the bailiff. Daniqua Washington.
She's pleading all, so all counts.
Okay.
And I have to make sure they bring her over to Mr. Hill. I'll do that when we finish.
Just a misdemeanor attorney. I can send them another receipt card for it. You want to know, you're not a prosecutor.
It might be Andrew.
Okay.
Andrew.
Good morning. Are you Shaniqua Diane Washington?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the motion?
Yes, Sharon.
Ms. Washington, in cause number 24, DCCR 2370, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation August 26th of 2025 for the offense of theft of property with previous convictions. And that was a deferred probation for 3 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the offense of failure to identify with intent to give false information on October 4th of 2025. Is that true or not true?
Listen.
True or not true?
Yes, true.
Thank you. Count 2 alleges that you failed to report as directed to the probation department in October of 2025. Is that true or not true?
True.
Count 3 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true? I'm sorry.
True.
Count 4 alleges that you were at a location other than your residence at approximately 1:23 a.m. October 4th of 2025. Is that true or not true?
True.
Count 5 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
True.
Count 6 alleges that you are behind in your court assessed fees. And is that true or not true?
True.
Right. Did you enter your pleas of true to counts 1 through 6 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've reached with the district attorney that you'll be waiving or giving up any right to appeal? So it looks like the agreement is for me to continue you on probation. There would be a 90-day jail sanction with credit for any time that you've been in custody on the motion, and that I would extend it for 7 months. 7 months is a bit of a random time frame. What's the reason for 7 months? Usually it's
We worked out 7 months because that's about the amount of time she has missed.
Okay.
Because of inaction or,
Because she was just placed on probation in August.
all right.
so it brings her back to to her original sentence?
I think what I would rather do, is you go ahead and do the full year. I appreciate Ms. French being generous with that, but I think if you didn't show up, you don't necessarily just get to back where you were. I think there needs to be a little further sanction than time served and getting back where you were. So, I understand that's the agreement, but I can extend it's up to me to do that, regardless of any agreement. So that is what my intention will be. I'm going to make a notation that,
Could be 1
yeah.
year.
Extended a year. State tenders number 1,
No objection.
it's admitted any evidence that Ms. Washington's not competent.
No, Your Honor.
All right, Ms. Washington, you're getting a great opportunity today. I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation. But I'm going to follow the agreement, with the exception of what I said as far as how long I'm going to extend your probation. I'm going to continue you on probation. I'm extending your probation by 1 year. I'm ordering, that you serve 90 days in jail as a sanction. You will only receive credit since you've been in custody on the motion to revoke your probation. I don't know how much you have, but you'll receive credit for that. And then, it sounds like you'll go from here, maybe down to misdemeanor court to take care of that other case.
Yes, ma'am.
You did not get off to a good start. I want you to understand that this is your second chance here and that you will not get a third. So if you violate probation again in any way, you're going to be back in here and you'll be looking at being revoked and going to prison. Do you understand?
Yes.
All right. I'm handing you the trial court certification that shows this was an agreement that I followed. So you have waived your right to appeal. All right. Good luck to you, ma'am. You can go back with the bailiff. Thank you, Ms. Fitch.
Yes, I'm gonna check with this today.
So we're just waiting on Mr. Vasquez and Mr. Burbank.
And she's shocked.
They still have witnesses on consequences again and all of that, before you sign these today. And obviously the evading arrest or detention would end up being, the most serious offense because it's a 3rd-degree felony, and with your criminal history, if those convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years up to life in prison. You understand? And all of these plea bargain agreements or rejections, are the same as before. It looks like 7-year, offers, all of the cases to go on either count one, whatever adds up to 7 years, waiving those habitual enhancements. Again, you've got every right to reject these. I do want to make sure you understand that once your case goes on the trial docket, I will not accept these plea agreements after today. Your case will be expected to go to trial, or there would be some different agreement. The only way it would be this or something lower is if some new information came out that your attorney or the state's attorney doesn't know at this time. Do you understand?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get them set on the trial docket and Mr. Eckhart will begin preparation for trial. You can go back with the bailiff.
Thanks, sir.
Sarah Jordan on page. We are resetting Sarah Jordan. She's on page 8.
Yes, ma'am.
He's not here again today. He has still has to be here. Okay, I'll deal with it in a second. Mr. Eckhart, you have Michael Victoria.
You, Judge. Michael Victoria.
Yeah.
And now Mr. Smith.
Good one.
Since she doesn't have that study.
Philip's been working on, getting an offer. We have that, I've got the discovery.
Let's get him out and then I'll let you. Good morning, sir. You're Michael Victoria.
Yes, ma'am.
And Mr. Victoria, in cause number 21-36410 and 21-36411 is charged with murder in each of those cases. And what is the announcement?
Judge, over the past few weeks, Mr. Smith has been working on getting us an offer. He did so last week. We've already kind of done some preliminary discussions about it. We're not prepared at this point to say yes or no. We still need a little bit more time to go through all the discovery, and we're asking for 60 days to do so.
Discovery is being in the sentence.
I'm sorry.
Discovery is going in the sentence.
So what I'm willing to do based on, and I know these are old and there's a lot of discovery. We talked about that before. I will do one last reset. I'll do a 60-day reset. That should give you plenty of time to get through everything yourself and then get through it with Mr. Victoria. And then when we come back, is there anything that we're waiting on that you know of? Okay. So now that you've got everything, we'll get an announcement one way or other at the next 4 days.
In 60 days, we will be able to.
Perfect. Thank you, Mr. Carter. You can go back with the bailiff.
All right.
You run what I have to put you reflection. You need to leave running up the flag.
And then like the, what restaurant was that? Where you, yeah.
He's running flag on here.
Mr. Rojas, are you ready on, Bradley Hudson?
Yes, ma'am.
Bradley Hudson. We just go, is there one or is there another coming?
I just need the second. What? Second.
We just going on one?
Yes, ma'am. One's gonna be dismissed.
Good morning, sir. Are you Bradley Aaron Hudson? And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
And are we going to count one only?
Yes, ma'am.
Second to get that quickly. It alleges you committed the second-degree felony offense of aggravated assault with a deadly weapon from January 9th of 2026. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Hudson is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time, follow your agreement, find you guilty of aggravated assault with a deadly weapon, sentence you in accordance with that agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will also sign a dismissal as part of this plea agreement and cause number 26 DCCR 0153. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.
They're gonna be reset, Judge.
All right, let me write this on this before I forget. Kelvin Johnson.
That's gonna be a, plea.
Okay, Kelvin Johnson.
Yes.
Good morning, sir. Are you Kelvin Johnson?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will.
Judge, with the court's permission, we need to go on second degree count, so if our court prefers.
Somebody didn't sign.
The defendant, I signed in the wrong spot. Sorry.
I didn't get him.
That's okay. Thank you. Mr. Johnson, in cause number 25, DCCR 1781, you're charged with the state jail felony offense of theft of property with previous convictions from October 9th of 2025. The indictment alleges you were previously convicted of theft August 18th of 2022 and January 5th of 2023, and then April 15th of 2024. The indictment further alleges that you were convicted of delivery of a controlled substance, a state jail felony, February 9th of 2004, 2 cases on that same date of delivery of a controlled substance. And how do you plead to that charge? And are those prior convictions all true?
Yes, ma'am.
Did you enter your plea of guilty and true, freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 5 years in prison, which means you're leaving your punishment up to me. And as long as I follow the agreement, I cannot give you more than 5 years. Give you 5 years, I can give you less, I can consider probation. All of that will be determined when we come back for sentencing and I get more information and a pre-sentence report and things like that. You have an absolute right to have a jury come in and decide 2 things. The first is to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to them. If we go forward this way, then you're waiving that. And is that what you want to do? Right. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Johnson is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. I find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do that report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas, and he'll present it to me on your behalf when we come.
Yes, ma'am.
All right, we'll see you back at sentencing. You go back with the bailiff. Then you've got Willie Pugh.
It's gonna be a rejection.
Okay, thank you.
Good morning. Are you Willie Edward Pugh Jr.? Give me just a second, Mr. Pugh, to get this pulled out. Mr. Pugh, in cause number 25, DCCR 1835, you're charged with a third-degree felony offense of unlawful possession of a firearm by a felon from October 23rd of 2025. The indictment alleges that you were previously convicted of the third-degree felony offense of unauthorized use of a motor vehicle, May 13th of 1996. 2 cases of that same offense on that same date. After those were final, you were convicted of the felony of unlawful possession of a firearm by a felon, February 20th of 2007. You were also convicted on that same date of possession of a controlled substance, a third-degree felony. After those were final, the indictment shows that you were convicted of evading arrest or detention with the use of a vehicle, April 15th of 2019. And on that same date, also possession of a controlled substance, a second-degree felony, and unlawful possession of a firearm by a felon, also on that same date. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison, up to 99 years or life in prison. Do you understand?
Yes.
I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty to go forward probably on, it looks like counts 1 and 2. That would make this a second-degree felony for a 14-year term in prison. You have every right to reject that. I want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty. And do you understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial?
Yes.
Okay, I'll get that done. Ms. Malfino, is there any reason to believe that that offer would change? Any information you think you don't have at this point?
Judge, just to be candid with the court and not to give the defendant any false hope, I'd like to speak with the officer actually in person rather than the review of his report. There might be some question as to the validity of that search. I'll certainly bring that to the court's attention well prior to the trial docket. That would be the only reason after speaking with him that I would consider altering the offer with the court's permission. He's been before you, Judge, multiple times with 10 and 12-year sentences reason for the
And
I
Judge,
could do that very quickly.
if you'd rather just reset a week or 2.
I would I would rather if you can get that done in 2 or 3 weeks, just to do a regular reset. That way we can all say with at least some certainty that the offer is what it is based on the evidence and based on your discussions, or if something changes, then we'll take care of it one way or the other. So let's do this. I'm going to delete that plea bargain rejection for now. I'll reset it for about 3 weeks. That'll give Ms. Malfino time to speak in person with that officer, get with Mr. Rojas. He'll get with you, let you know what the final discussions come out to, and then we will see where we get at that next court date. Okay, you can go back with the bailiff.
This might read different on the problem because the
Okay,
conversation.
sure. Yeah, that's good. Brian Trejo.
I'm going to ask for a reset on that, Judge. I'm still trying to run down witnesses that were.
Okay, it's pretty new. Mr. Nichols, and we'll set Brian Trejo. I think that's all you have.
Sarah Jordan's going to be reset along with the co-defendant.
I think I already got that one. Yeah,
That's it. Thank you.
thank you.
Good job. Good job.
Mr. Parker,
Yes, ma'am.
you've got Christopher Holman. Okay.
I got to text with the guys. We go out on Wednesday. Ruben from office, send me a picture. Parker's crawling.
Mr. Coleman?
Morning, Judge.
We need them to get a fingerprint real quick first, please.
Work out two.
I got everything resolved with you. It's only Ashley that I'm.
I wasn't trying to call out anybody.
Pretty bad.
Just pointing.
We did. Thank you. I'll make it this week.
Good morning, sir. Are you Christopher Holman? Speak up, please.
This one.
And Mr. Parker, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Holman, in clause number 24, DCCR 0814, you're charged with the state jail felony offense of theft of property with previous convictions from February 7th of 2024. The indictment alleges you were previously convicted of theft August 4th of 2020, and then after that was final August 10th of 2021. And how do you plead to that charge?
Guilty.
And are those prior convictions of theft true? Speak up, please.
Yes, ma'am.
And did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they charged you with. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Holman is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. And at this time, in accordance with your agreement, find you guilty of theft of property, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You can go back with the bailiff. Okay, Enrique Garcia. Did you do this?
I gave it to her. Oh, I'm sorry.
Oh, we did the wrong one.
Oh, I had it in the wrong file, I guess.
You know, there's, you need certain defendants up there to make sure you do that right.
Oh, very French. Oh, she does.
Your Honor, the state's electing to proceed on 1244. We're asking the court punish this defendant as a misdemeanor.
With a state jail felony conviction.
Yes, Judge.
Yes.
Good morning, sir. Are you Enrique Garcia III? And Mr. Tucker, will your client waive the formal reading of the indictment?
You would, Judge.
Mr. Garcia, in cause number 25, DCCR 1057, you're charged with the state jail felony offense of unauthorized use of a vehicle, and that's from June 11th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving him any right to appeal? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Garcia is not competent?
No, Your Honor.
All right, Mr. Garcia, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of unauthorized use of a vehicle, sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Park. All right, good luck to you, sir. You can go back with the bailiff.
Judge.
See, Donald Cogdill.
He's gonna be a little bit difficult. He's not combative. He's just.
Last time he said.
No, I'm
that.
telling you, make
Okay.
sure he's like questioning the, I was my thing 100 times and.
All right.
I thought they would just come back with another offer. I mean, this is the best offer. Try to go through it with it. He starts questioning me. I'm the judge. This is the judge. Well, I understand.
She didn't call last week and say, can I just told the bondsman, I'll let you know. So I don't know.
Yours, Lana.
Yeah, I mean, she went into rehab Friday. So, her bond will be forfeited for non-appearance and reset at 100,000. And then if she calls her, they can get in touch with her, maybe tell the bondsman if they'll get her here next week. I'll maybe recall it, but she doesn't get to just go. Yeah. But we can let her call her and get her here. Ronnie Oliphant. Good morning, sir. Are you Ronnie Oliphant? And Mr. Oliphant, looks like this is your initial appearance. Hold on a second. In cause number 25, DCCR 0379, you're charged with a third-degree felony offense of injury to a child, elderly, or disabled individual from February 18th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, I had one, but released him, but I was trying to see, can I get a lawyer on my own? I had a court-appointed attorney.
Yeah, so that's what I want you to do is hire your own attorney if you can. So what I'll do is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you go back to jail. Do you understand?
Yes, ma'am.
All right, step in front of the clerk. She'll give you your reset. Lisa Pratt.
Pretty good, thank you.
Good morning, ma'am. Are you Lisa Pratt?
I am.
And Ms. Pratt, this is your initial appearance. In cause number 24, DCCR 1460, you're charged with the state jail felony offense of theft with previous convictions, and that's from April 1st of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
They assigned me a lawyer.
They did. So when you're in custody, we give you a court-appointed attorney, but now that you bonded out, what I do is expect you to at least try to hire your own. So I'm going to reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. You need to bring me back the names of the lawyers that you've talked to, and so I know you're trying. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order. Do you understand?
Yes, I do.
And are you working?
I'm on disability.
You are. If I test you this morning, you can have anything in your system?
I do, no.
Have a seat in the jury box. Let's double check what you got in there. Have a seat in the jury box. Carnell Beard. Good morning, sir. You're Carnell Beard?
Yes, ma'am.
Did you get someone hired?
No, I've spoke with, Kevin Lane, Ms. Holmes, Mr. Smith. What they asking me for down, I barely make that a month. I'll show you my check. I work for
Well,
the city of New Orleans.
Let's do this, Mr. Beard. Thank you for visiting with some attorneys. I'll have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to make sure to fill it out accurately and completely because you're going to swear under oath that it's all true and correct, and then I'll take a look at it. Okay? Step in front of the clerk. She'll give you that paperwork. Donnell Coleman. Good morning. Are you Donnell Coleman?
Yes, ma'am.
And Ms. Coleman, this is your initial appearance. In cause number 25, DCCR 0222, you're charged with the state jail felony offense of abandoning or endangering a child with intent to return from January 26th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am. I didn't really have the understanding of it.
No, that's okay.
When it
This-
went, so
that-
like when I did call to get in touch with them, they had mentioned they had dropped my case, so I didn't know what that meant.
Well, they didn't drop your case. As far
Charles Rojas, I think.
Yeah, so Mr. Rojas was appointed while you were in custody. And so now that you are, and he's still your attorney unless you hire someone else or we make some other,
So I can't still get in touch with them.
you can get in touch with him, but here's what I expect you to try to hire a lawyer. So you can talk to him about hiring him or anybody else. I'm going to give you about 30 days to try to get someone hired. If you hire someone before the next court date, bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers that you talk to when you come back, so I know you're trying, and then we'll discuss your options, okay? If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, step in front of the clerk right here. Yes, ma'am.
I know the stipulations with my case was saying that I couldn't jail my kids. But I mean, I have been going to like parenting classes.
So that's probably one of the, just as big of a reason for you to get a lawyer so we can get your case handled. And if you're doing,
I did parenting classes.
are you doing that through CPS? CPS involved?
At a church, yes, ma'am.
Okay, keep following everything that CPS, whatever their service plan is, keep following that. A condition of your bond is going to be that you not have at least no unsupervised right now. So if they're allowing you contact, it needs to be supervised only, okay?
So if I am able, someone has to be there.
Mhm.
Okay.
Until we say something
I'm
otherwise.
graduation and everything.
Well, just make sure it's supervised right now and get you a lawyer and we can move your case along and hopefully get you where you need to be with your kiddos, okay? All right, step in front of the clerk. Precious Eaglin. Good morning, ma'am. You're Precious Eaglin. And Ms. Eaglin, you are here on 2 cases, initial appearance and cause number 25 DCCR 0317. You're charged with the 2nd-degree felony offense of assault on a peace officer. And cause number 25 DCCR 0318. You're charged with the 2nd-degree felony offense of aggravated assault with a deadly weapon. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I spoke with Mr. Burbank, but I haven't officially hired him because I'm talking to somebody else.
Okay.
It's like the amount he wanted as well, so he could call somebody else and see.
Okay, so what I'll do is give you about a 30-day reset to either get Mr. Burbank or someone else hired. If you get someone hired, just bring the reset notice that you get today to that lawyer. They'll tell you what to do.
Yes, ma'am.
If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers that you talk to when you come back so I know you're trying. Then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand? All right, step in front of the clerk. She'll give you that reset notice. Shadaman Mitchell. Shadaman Mitchell.
No response, John.
Bond will be forfeited for non-appearance and reset at 100,000. Jeremiah Paia. Good morning, you're Jeremiah Paia?
Yes.
Paia. And Mr. Paia, did you get someone hired?
No, ma'am. I talked to 3 different ones. They all said about the same price.
Who'd you talk to?
Walker, Mr. Walker from Liberty, someone from Liberty, Mr. Walker from Walker Law Firm, someone from Crenshaw from the name.
Okay,
And they all said about the same price.
all right. You didn't write those things down for me?
No, ma'am. It was on my phone,
Okay, where's your phone?
in my pocket.
Look it up, let's see.
And then the one from Liberty, they just told me over the phone like 7,500. They
Okay.
didn't tell me their name or nothing. Same for Crenshaw.
What do you mean they didn't tell you their
I was
name?
asking, I was like,
Well, how did you call them? Who'd you
I
call?
called on my phone. I just called the law firm.
Right,
And they didn't put me through to nobody. They just said 7,500. But Mr. Walker, I didn't catch his name, but I talked to him for about 40 minutes. on the
Okay.
phone.
good.
And he was just telling me everything about like what he would do, this,
Mhm.
whatever, and what a lawyer would do, and everything all like that.
Are you working?
Yes, ma'am.
Okay. So do you think you're gonna be able to get one of them hired?
Because Mr. Walker, he said he had payments, but he didn't really trust me that much because of people in the past. So
Where are you working?
FedEx.
Okay. So here's what I'm gonna do. I'm gonna reset your case one more time for you to talk to some other attorneys. Because there are some out there that charge different amounts than what you've done. So go talk to at least 3 more. See if you can get someone hired. If you can, great. If not, bring me those names of everybody you've talked to. Then we'll discuss what your options are, okay? You don't have to limit it to just 3.
Yes,
The
ma'am.
point is to hire someone. So call as many as you can, make as many appointments, get, so that you can see if you can get someone hired, okay?
Yes, ma'am.
Step in front of the clerk. Kevin Diaz. Good morning, you're Kevin Diaz. And Mr. Diaz, this is your initial appearance in cause number 25 DCCR 0418. You're charged with the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from March 5th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No.
Okay. How old are you?
19.
All right. So what I'm going to do, Mr. Diaz, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of who you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? All right, step in front of the clerk and she'll give you your reset notice. Zachary Turner. Good morning, sir. You're Zachary Turner?
Yes, ma'am.
And Mr. Turner, this is your initial appearance in cause number 24, DCCR 2197. You're charged with the first-degree felony offense of fraudulent use or possession of identifying information, and that is from April 22nd of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Okay. Looks like you also have prior felony convictions, so it's going to be very important that you try to get someone hired. What you're charged with is extremely serious, obviously. So what I'm going to do, Mr. Turner, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes, ma'am.
All right, step in front of the clerk. She'll give you the reset notice. So the next one, Dylan Wilkinson. Dylan Wilkinson. That one has an AFRS. How you doing today, Pickens?
Good.
This bond will be forfeited for non-appearance and reset at 100,000. See, Mr. Jones, come up, sir. All right, you're Jamarcus Jones. It's very important that you're here on time. So I'll recall the bond forfeiture. And Mr. Jones, this is your initial appearance. Give me just a second. So you're on probation for theft of a firearm. I set a bond on that probation, and now that you've made that bond, I expect you to try to hire a lawyer. So what I'm going to do is reset your case for about 30 days, and you need to try to get someone hired before that next court date. If you do, just bring the reset notice that you get today to them. They'll tell you what to do. If you're unable to, then you need to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Make sure you visit with them, bring me back the names of who you've talked to, and then we'll discuss your options. If you don't do that, then when you come back, I'll raise that bond back up and you'll be back in jail. Do you understand? It's also important you're still on probation. You need to be doing every single thing you're supposed to be on probation right now, because if you don't, that's only going to make things worse. All right? Okay, step in front of the clerk. She'll give you that reset notice.
Thank you.
She's saying she can't go because she's on dialysis and heart failure and stuff, so she can't go to the restaurant. I know she can eventually.
Oh, no, that's what I told her. He said, you're gonna have to do it.
Yeah, it'll be a positive if not. I know. I feel like there's probably maybe more to it also, just based on. Let's see. So, are they all going to be here on the Capitol?
I mean,
That's what I thought too.
And then I saw the TDC guy.
See, is Miss Jordan, Mr. Brewer? Are y'all ready for an announcement?
Yes, Your Honor.
It's, we need Trishad Tarrant, please. Good morning. State this side, defense this side. Not that it really matters, other than the fact that it keeps it straight in my head. Good morning. How are y'all this morning?
Good, how are you?
Good.
I saw you went viral about 2
Oh.
months ago.
There's a few of them out there, unfortunately, yeah.
No,
It depends.
unfortunately, yeah. It was actually very entertaining.
Good morning, sir. You are Trishad Tarrant, and Mr. Tarrant is charged with capital murder of a person in a prison. Mr. Brewer, Ms. Jordan, where are we, and what's the announcement?
Your Honor, the state is announcing ready. We have no pretrial at this time. I believe I have offered a formal plea offer to the defense.
And she has, that offer has been forwarded to my client. I will at this time probably say that we will probably going to set this back to trial. If we could, perhaps February of next year, just move on.
Well, it'll be when it'll be. But what I do want you guys to do, if there's a formal offer, I'd like to get a formal rejection of that. I have those forms on the tablets. We can get, maybe Mr. Rojas or Mr. Parker can help you fill out that formal. If you don't want to accept a plea agreement, I'll go through that today. Once we do a rejection, the case is placed on the trial docket. Typically, I don't accept that same plea agreement. You could plea open to the court. It could be something different unless there's new information that either of you get between now and then. So once it goes on the trial docket, it'll be expected to go to trial, or it'll be something different because of some information that you guys received. So I'll hold it. If you want to grab one of those tablets. Mr. Rojas, would you mind helping? Thank you very much, sir. And as soon as you do that, I'll go through all of that, bring you back up, and then we'll get it set for trial and look at kind of everybody's, how long we think that might take, and then we'll schedule it around that. But we're definitely not anywhere close to looking into February. We're looking at this year probably, based on our, unless there's some big reasons, but we'll see where we get, okay?
Okay.
All right, I'll hold it while y'all get that taken care of. Mr. Kimler, you have Tajuan Mack.
Yes,
He's on bond.
Gotcha.
I think he's on bond.
Yeah, there shouldn't be many on. Tajuan Mack.
I went out to the jail last night to see him. He said he was on bond.
Okay, but he has done it now. He's
done it since you ordered him to.
Okay.
It's just not been long.
Okay.
He may be running late, Your Honor. I did go out to the jail last night and they informed me he was on bonds.
Yeah, he's on bond. His bond will be forfeited for non-appearance, reset at 100,000. Obviously, if you get in touch with him and he shows up today, I'll reconsider that. But it is set for trial to begin with jury selection on June 2nd.
I am ready.
Okay.
Your Honor, if he goes into custody, I'll still be able to try it.
All right, I'll number the case. Obviously, if anything changes, you'll let me know.
Yes, Your Honor.
Okay. And then you have Joshua Mays, Mr. Kimler. Joshua Mays.
The owners would have to cover that. Yeah, they're all over. He's speaking to this. He's probably gonna start making rich with our towns.
That's what I said, orange, in orange,
Good morning, sir. You're Joshua Mays, and Mr. Mays is on probation for burglary of a habitation. Motion to revoke has been filed. What's the announcement?
Your Honor, if the court would, entertain going through the motion with the enter please, and I'll get it updated pretty soon.
There's no agreement.
No, Your Honor.
Give me just a second.
Good morning.
Good morning. Mr. Mays, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. And will he waive the formal reading of the motion?
So late.
Mr. Mays, in cause number 20-36100, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 13th of 2021 for burglary of a habitation, and that was a 3-year deferred probation. Is that correct?
Yes.
I'm assuming that's been extended. Otherwise. So it alleges in that probation, or in that motion, that you violated your conditions of probation. Count 1 alleges that you failed to report to the probation department as required for the months of October and December of 2024 and January of 2025. And is that true or not true? Count 2 alleges that you failed to provide verification of participating in the GED program. Is that true? Just today, it's just true or not true, and then we'll get explanations later. It's not true, okay. Count 3 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy, that MRT program. Is that true or not true? And count 4 alleges that you're behind in your court assessed fees. As of January 15th of 2025, you were $3,685 behind. Is that true or not true? All right, did you enter your pleas of true to counts 1 and 4 freely and voluntarily? Speak up, please. And did you plead true to those because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 1 and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case so that we can have a sentencing hearing. I'll get probation to do an updated report. Looks like we probably will only need a probation officer, so we can do that on a normal day. Shouldn't take long. All right. And so you need to stop and talk to probation on your way out of the courtroom so that they can make sure and tell you what you need to do to get ready for that sentencing hearing, okay? All right, we'll see you back then.
Mr. Mays.
Oh my gosh, man, I don't know what's happening. Fuck, I need to sneeze. Mr. Pageant, you have Damian Douglas.
I'm doing a dismissal on that right now.
Okay, I'll sign that and he's free to go. Thank you, Mr. Pageant. Mr. Price, you have Dale Johnson, 3 cases. She can have that back. Dale Johnson? Okay.
Cornell Beard.
Morning. Good morning, ma'am. You're Dale Johnson, and Ms. Johnson is charged in 24 DCCR 1570 with indecency with a child by sexual contact in 24 DCCR 1571 and 1572 with aggravated sexual assault of a child. And Mr. Johnson, what is the announcement?
Not ready, Your Honor. Our investigation continues. We have served subpoenas on 2 school districts. We're awaiting those records. I understand we're also awaiting some records from Texas Department of Family and Protective Services.
Okay.
Agreed order, court signed.
Okay, that should be, that was signed back at the end of February, and I see your subpoenas. All right, so let's do this. I'm going to do maybe a 45-day reset instead of a 30. Hopefully we'll get somewhere on all of those documents, the CPS as well as what you've done, and see if we can get an announcement at that next court date. Make sure you stay in touch with Mr. Price. He'll let you know when you need to be back. All right, thank you. Mr. Samuel, you have Tyreek Flanagan?
Yes, Your Honor.
Good morning.
Good morning. How are you?
Doing great. How about you?
It's a great day to be alive.
It is. Every day is, right?
Yes, ma'am.
Good morning. You're Tyreek Flanagan. And this is cause number 23 DCCR 2310. Mr. Flanagan's charged with indecency with a child by sexual contact. What is the announcement?
Your Honor, we've gone back and forth with this quite some time.
We have.
I don't think we have any choice but to set it for trial.
Okay.
There's an issue with the outcry person. There was a CPS case in Harris County that was dismissed because of the source. And we've not been able, we tried to get that information. The state has tried through CPS, but we're not getting it. So we don't have much choice but to set this for trial.
I mean, I'll order it.
Well, that's the thing, Judge. We've done that and we've reordered it.
I see that. We've done a second.
And what we're still getting back is the same set of records.
But it's not the records that show the dismissal
Right.
and why over in Harris
Do y'all
County.
want to do a very specific, try one more time with some,
And I talked with Kelly Friday. I was on the phone with Miss Adams, who's a regional attorney.
Right.
About, but we're getting another copy because our copy is gone. However, the newer stuff wouldn't have been in it. This is newer allegations that's happened since I've been on the case.
so are they going to work on getting that?
That's-
Did she say that?
I didn't get a specific, I'm still trying to get the original records. So we've sent this a second amended that I wrote specifically to get newest, and it still didn't come back. So.
Okay,
that was
but you
part of
talked
that.
to her and she knows.
That we're trying to, her assistant is getting me stuff. I'm in contact with her,
Okay,
but the newer stuff is the problem, dude.
right, but I don't want it to be. I'll call her, we'll call her. We've had no issues dealing with her if we need something. So if y'all need me to do something, I want to get it done.
We just need to know the basis of the dismissal in Harris County. That's the same culprit.
Do a joint email to me today with the two of you guys and me saying what you need. And then I'll forward that and give Stephanie a call and see if we can find out what we need to actually get that specific information.
And I just want to let the court know, like, since I've been dealing with the council on this, I've reached out to the Houston office, CPS, to find out if there's information that is get through that office as opposed to going to Austin.
Right.
The way we go, I've not gotten a response. And
Okay.
I've gotten turnover and all.
Send me something today and then we'll try to, and before we put it on the trial docket, let's do one more reset. Let me reach out to Miss Adams, see if there's something she can do to help us with that Houston information.
Yeah.
And then there's gotta be a way to get it. So I'll call whoever I need to call.
Thank you.
Okay. Stay in touch with Mr. Samuel. He'll let you know when you need to be back. And then you've got Daisha Mark. It looks like that's set for a plea. Mr. Samuel, you're going to work on that?
Yes, Your Honor.
I'll hold that for you. Mr. West. On Ramadan Castillo, 3 cases. Can I get a trial docket?
Yes, we did. Something happened, I don't know what happened, but. Yeah, that's right.
I think that's what happened on this.
Yeah.
Yeah. Good morning, you're Ramadan Castillo. And Mr. Castillo is charged in each of his cases with aggravated sexual assault of a child. It's set for trial to begin with jury selection Monday, June 2nd. And what is the announcement? All right, well, obviously, it is one of the older cases. I anticipate it being at the top. We'll find out, I guess, actually next week, because we'll have a docket next Tuesday. But I anticipate it being up there. If anything happens between now and next Tuesday, let me know. There won't be any plea agreements after that. So if anything changes, y'all get together, and otherwise, we'll try to get it taken care of on that day. All right, stay in touch with Mr. West to let you know when you need to be back. Mr. Parker on Benjamin Barker. Good morning. How are you? Good morning, sir. You Benjamin Barker? And going to first take judicial notice of the court's file and cause number 24 DCCR 2194. And Mr. Barker was evaluated for competency to stand trial. We received and was found not competent, was sent to the John Dunn Behavioral Science Center for competency restoration, was restored, and I received that packet dated April 1st of 2025 with the finding that Mr. Barker is competent to stand trial. It includes the evaluation report, and that is from Dr. Guzman, as well as the attending physician's report of patient progress. And so is there any other evidence with regard to competency?
None I'm aware of, Judge.
Not from the state, Judge.
Then based on that, at this time, I am going to find Mr. Barker competent to stand trial. He's charged with harassment of a public servant. And what is the announcement?
Your Honor, he informed, I haven't talked to him today. He just got out of jail. He told me 2 weeks ago. He's had multiple injuries and his foot is broken. And I haven't talked to him. As of now, he wanted to do a rejection, but I thought, being that I hadn't had a chance to talk to him in detail, that it may be worth resetting.
It is. Let's do this. Mr. Barker, I'm going to reset your case about 30 days. You need to make sure and call Mr. Parker, visit with him either in person or on the phone, your attorney, before that next court date, and he can go over everything that he knows about your case, that he's received from Mr. Coleman, what your options are, and then we'll get an announcement at that next court date how you want to proceed, okay?
And I've also indicated to him that he could hire his own lawyer, and because he kind of indicated that may be something he wanted to do.
If you have the funds and you want to, then you need to hire your own attorney for sure. If you're unable to work and you can't afford one, I'm going to leave Mr. Parker on if you can't afford one. But if you can obviously hire your own. If you're not going to do that, you definitely need to call and talk to Mr. Parker about your case. Okay? All right. We'll see you back in about 30 days. Forfeiture is here. Didn't get you back. They already said they're ready. So I don't know. Whatever. Show website. Station 19. Tajuan Mack. He was upon forfeiture that showed up. Mr. Mack, Mr. Rojas, Mr. Kimler was here already. We called your name. You need to be here on time, okay? Otherwise, you're going to end up with a bond forfeiture and you'll be put in jail, and you don't want that to happen. So I'm going to recall the bond forfeiture. Your case is set for trial to begin in a couple of weeks. The attorney's announced ready. So I'm going to number the case for trial. You need to stay in touch with your bondsman and Mr. Kimler, and they'll let you know when you need to be back and ready for trial. It'll be in 2 weeks. Okay, you're free to go. Say Rochelle Manuel, Mr. Parker.
She's outside. Michelle Manuel. I don't think Margaret showed up, or he had tested phone.
Good morning, you're Rochelle Manuel. Yes, ma'am. And Ms. Manuel's charged with aggravated assault causing serious bodily injury. What is the announcement?
Your Honor, she's been very good about staying in contact with me about updates and all that. We have a new plea offer that Mr. Nichols gave us today. She wants to accept that offer. She told me this 2 weeks ago that she's trying to be responsible. Her apartment lease expires this week and she gets her last check. And she's going to plead to pen time, and she wanted to wait to plead out next week if we could, so she could take care of her affairs. And I feel certain that she's going to plead.
Why don't we do that? Why don't y'all do the plea and I'll just reset it for sentencing, but we don't need to get a PSI, but that way we get that first part taken care of. And
I'll do that, Judge.
all right, I'll hold it while y'all do that.
I don't think another one's here.
Gustavo Vasquez. Gustavo Vasquez.
Yeah.
All right, well, this was the last reset, so I'll hold it for y'all to do what. Mr. Rojas, you have Jardel Elam. It's a sentencing. Oh, where'd Mr. Rojas go? Oh, hi. Jardel Elam.
Jardel Elam.
I had him tested this morning. She tested positive on May 5th. So I just want to see if there's where we are. Yeah. Mr. Elam, I'm going to have you tested this morning before we go forward. Have a seat in the jury box. Let's see if you got anything in your system. And then Nicholas Gilmore Jones, Mr. Rojas. This, Mr. Hoffpower. Good morning, sir. Are you Nicholas Gilmore Jones? And Mr. Rojas, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Jones, in cause number 24, DCCR 1441, you're charged with the state jail felony offense of solicitation of prostitution from March 28th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. you would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Gilmore Jones is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea. Is there some history? Is that why it's a 2 over 5?
It is, Your Honor.
So I'm going to find sufficient evidence to find you guilty. However, I'm going to reset your case so that I can get a pre-sentence report done. That'll just give me more information about you, your case, any history, and then we'll go forward with sentencing at a later date. You need to stop and talk to probation before you leave the courtroom today, and she's sitting at that desk right there, okay?
Yes, ma'am.
We'll see you back at sentencing. Which one? I was about to say it's not.
I'm sorry.
Okay. Miss Mitchell, come up, ma'am.
Sorry about that. I was late because I had to run back home and get the paper.
Okay, I'll recall your bond forfeiture, and you're Shadamon Mitchell, right?
Yes, ma'am.
So did you get someone hired?
No, ma'am, I did call around to a couple places.
Good, who'd you talk to?
I talked to Grace Kelly Law Firm. They told me it was gonna be about 5,000, but my dad said it was a little too much, because he was the one helping me pay. I called Sheila and officers, no one ever gave me a call back. James R. Merkin, I think they told me $5,000 again. Dunham and Jones gave me an offer for $3,000. A flat fee, we pay 15 up front and then 200 every other week.
Mm-hmm.
So we were thinking about going through, but we just ran out of time.
Okay, so you still think you'll be able to get someone hired?
Yes, ma'am.
Thank you for doing everything I asked you. I'll reset your case about 30 more days to give you some time to hire one of them or someone else.
Yes, ma'am.
If y'all get someone hired before the next court date, just bring that reset notice that you get today to the lawyer.
Yes, ma'am.
If for some reason it's not going to work with them, make sure you call some others, bring me those names, and we'll discuss your options when you come back. Okay? All right, you can step in front of the clerk and she'll give you your reset notice. See, Mr. Is Mr. Brewer get that rejection sign? I guess not yet, huh?
He's still having.
Okay, that's fine. I'm not in a hurry for him. Let's see, Miss DeLage, we haven't seen her, Mr. Galmore, Mr. Gertz, Mr. Crenshaw. I saw Brittany come through. And then Macon's down in. Holden. Yeah. Yep. 'Cause that's. Okay.
Michelle Manuel.
Good morning. Are you Shalora Dawson? And Ms. Dawson was previously in court, entered a plea of guilty to the. All right, we'll see you back then on the 2nd at 9 o'clock.
Yes, ma'am.
Okay, thank you.
We just need to go through the motion on Gustavo.
Okay. Gustavo, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you, Parker, on Rochelle Manuel. Tim. All right, ma'am, again, you're Rochelle Manuel, and will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Manuel, in cause number 24, DCCR 1050, you're charged with the second-degree felony offense of aggravated assault causing serious bodily injury from April 5th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like that agreement's for a 3-year term in prison. Is that your understanding?
Yes.
And it's your understanding I'm going to take the plea today. I'm going to reset it for sentencing next week.
Yes, ma'am.
And we'll talk about some important things about that in just a minute, but that's what you want me to do, correct? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
All right, state tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Manuel's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, but I'm going to hold that and I'm going to reset your case for 1 week for sentencing. Actually, I guess we could do it on Tuesday. We don't have a Monday docket. Is Tuesday big? Should we do, I'm going to reset it for 2 weeks. I think that'll be easy. No, let's do it next Tuesday.
Yes, ma'am.
June's 2 weeks. Okay. We're going to reset you for 2 weeks so that you come back on a Monday.
Yes,
Because we don't have a Monday docket next week.
Yes.
So a couple things about that are very important. Obviously, if you don't show up on the 2nd to turn yourself in and for me to sentence you, this plea agreement's gone and things could be a whole lot worse. You understand?
Yes, ma'am.
If you're arrested for anything between now and that court date, things could obviously go bad and I don't have to accept the agreement. You understand?
Yes, ma'am.
All right, we'll see you back then on the 2nd at 9 o'clock.
Yes, ma'am.
Okay, thank you.
We just need to go through the motion on Gustavo.
Okay. Gustavo Chavez, 23-41422.
Vasquez.
Vasquez. What did I say?
Okay,
Vasquez.
It's Gomez Vasquez. You said Gomez Vasquez. What?
I thought that's what you said.
I thought I did, but I
I
don't
thought you said
know.
Gomez.
I might have said.
I don't know.
Good morning, sir. You're Gustavo Gomez Vasquez. And,
Oh, she said Chavez.
oh, I did? I just totally renamed you then. I'm
We
sorry.
have that Gustavo Chavez.
I do. I have that name, so hold on just a second. Let me get this pulled up the right way.
Oh. I didn't give you.
On the last one.
Oh, did they?
Oh, they didn't
Oh, I didn't
sign
get her
it.
to sign it. I'll bring back Tennessee.
Okay. All right, Mr. Gomez Vasquez, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. And will your client waive the formal reading of the motion?
You will, Your Honor.
I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation March 11th of 2024 for the second-degree felony offense of indecency with a child. And that was a 10-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to successfully enter and complete an approved sex offender treatment program. Is that true or not true?
The program, I'm going to those classes.
Just, is it true or not true? If it's not true, then we'll just have a hearing. Okay. Not true to count 1?
Yes, ma'am.
All right. Count 2 alleges that you failed to register with the sex offender tracking program. Is that true or not true?
No, it's true, but
Okay. So did you enter your plea of true to count 2 freely and voluntarily? And because count 2 is true. All right, then I'm going to find that you entered your plea of true to count 2 freely and voluntarily. Find that count true, find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case for a sentencing hearing. Mr. Hoffpower, you can bring whoever with regard to count 1, please.
Probation officer.
I don't anticipate that would be long, so
No.
we'll just do it on a regular day.
Just for the record, so he understands what I've explained to him, I'm explaining to the court, is that he has explanations of things he's done. And
Sure.
I've said, but it's whether you did this or not, and so he has some reasoning or explanation for all this. Which I
We'll
told
get
him
the
court will hear.
explanations at a sentencing hearing. And so what'll happen is I'm going to have probation do an updated pre-sentence report before sentencing. That'll give me more information about what's been going on. And then when we come back, Mr. Parker will be able to present to me anything you think is important on your behalf. Mr. Hoffpower will be able to bring any witnesses with regard to that count, and then I'll decide what to do on that day. Okay? All right, you are free to go. Thank you.
thank you.
Ms. Holmes, you have Shalora Dawson. It's a sentencing. No, just in jail. Good morning. Are you Shalora Dawson? And Ms. Dawson was previously in court, entered a plea of guilty to the state jail felony offense of abandoning or endangering a child. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, sir.
Ms. Dawson, if I test you this morning, you can have anything in your system?
Oh, no, ma'am, I did.
Let's, we're gonna double check this morning before we go forward. Have a seat in the jury box.
On my thing, she told me to tell the truth.
Yes.
I bought her the dispensaries and everything, but she said that.
But-
THC.
Right, so did they tell you probably shouldn't be doing that, so you don't test positive, so I don't think you're using something illegal?
No, because it wasn't me smoking, it was something like a gummy that was supposed to help relax me.
Right, but if it's gonna test positive, then I'm gonna assume the worst. So we'll get to that in a minute. I wanna test you this morning, see what's in your system, then we'll go forward in a minute. Have a seat over there in that jury box. Willie Richards, Ms. Holmes, it's a sentencing.
He's also.
Willie Richard.
Just, I've got my stuff, I've already dismissed. There was 2 of them, and I dismissed one of them outright. You ever dismissed them?
On Richards.
Just follow them on Richard.
Unless it's already been dismissed, it looks like, because it's not on the docket. Good morning, sir. You're Willie Richards. Mr. Richards, you were previously in court, entered a plea of guilty to the second-degree felony offense of indecency with a child by sexual contact. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, sir.
Are there any additions or corrections?
No,
No, I just had a couple questions.
Okay.
In regards to the supervision plan, Mr. Richards, he plays the drums at his church every Sunday. Does that need to cease, or we were just needing clarification so he's not in violation?
At a regular service or something specifically with regard to kids or?
At regular church service on Sunday.
If they get to her.
The guitar, I'm sorry.
Okay. Yeah, I'll look at that in a second. Anything else that you want?
And the polygraph, we were just wondering what that was.
That's part of probation for any sex offender.
Oh, okay.
Yeah,
That was it.
that is to make sure that they're doing what they're supposed to and not doing what they're not supposed to be doing. I'm assuming, Mr. Hoffpower, that you've visited with the family and I would think that
There is if you read an order, there is a restraining order for the complex where this occurred.
Right.
And it's in place.
well, and I would think that somewhat the special needs of the victim is why this offer
Right.
was made.
Yes, Judge.
I mean, Mr. Richards, this is. You're 60?
Yes, ma'am.
I mean, what you did was ridiculously terrible to a young girl that already has her own set of issues. All right. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. However, I am going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $500 fine and you're ordered to follow all of the rules and conditions of probation. That includes obviously being on the sex offender caseload, following all of those recommendations. I will allow you to play in the band at church. You are, however, specifically ordered, and part of your probation is you cannot be alone with any child under the age of 18. Period, ever, never. Do you understand? You obviously cannot be on the premises of the Carlisle apartments. You can't be anywhere near or have any contact or communication with the victim in this case as well. If you do everything you're supposed to, get the treatment that you're supposed to get, make sure that you're doing all of that, then this is an incredible opportunity because you do not have this conviction on your record. And if you successfully complete the probation at the end, the case is dismissed and you will never have this conviction. The other side of that, though, is if you violate any condition of probation, you will be brought back into court, you will be found guilty, and then I can sentence you to prison anywhere in the range of punishment, which is up to 20 years in prison. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. All right, good luck to you, sir.
Yes.
You've got Daryl Spencer, Ms. Holmes.
Yes.
Daryl Spencer.
He's here. I didn't know he was here. I thought he was still in. I thought he was still in. Where? He just got out of Orange. That's the one he was in Orange County. I thought he was still there. I didn't know he was here today. Does he have a warrant for here? Hold on, Mom.
Yes.
Okay, he said he has a traffic ticket warrant, so you'll have to go in today. All right, you're Daryl Spencer. And Mr. Spencer, you're charged here with possession of marijuana as well as evading arrest or detention with the use of a vehicle. And is there an announcement?
Not yet, Judge.
Okay.
I need to meet with him.
So I'm going to do a normal reset about 30 days. So you'll go in custody today. If you set out your tickets or pay them, whatever happens, that shouldn't take that long. As soon as you're out, the first thing you do is contact Ms. Holmes so you guys can go over whatever it is she knows about your case, and we'll see what the announcement is at the next court date. All right, you can go back with the bailiff. Ms. Pratt, are you gonna be able to use the restroom this morning?
was gonna talk to you about my medical.
Okay,
I don't know. They told you.
they did, but I know that even with that issue, you still go to the restroom.
3 days or so, yeah.
So why are you,
When
come
you
up,
draw blood, I mean,
well, we're not gonna draw blood. Come up here.
put your water here. Oh, my water.
Yes, you're gonna go before the judge.
When's the last time you smoked marijuana?
It was one of those little gummy things from the vape store.
Uh-huh.
I guess it's THC, but.
Why are you-
I just said marijuana, but it's THC, which I thought was the same.
It is the same. It'll show positive.
Okay.
It's all derived from the same stuff. And if you have a felony court case pending, I would think you wouldn't want to have anything in your system that would have you test positive, right?
Well, I'm not sure if it will. It was like a month ago. I'm on probation. I've been on it for almost a year.
Where,
It's in
from where?
Jasper County,
Okay.
and, they know about all my medical. I need a heart valve replacement, and I have a liver failure, and now it's resulted to the kidneys.
Okay.
So he,
Sounds like you need to quit doing stuff to get yourself in trouble so you can
I do.
stay
I
out
do,
and
like,
take care of yourself.
I do, I know.
So, what I'm gonna do this morning, Ms. Pratt, is reset your case for you to hire a lawyer. You need to try to get a lawyer hired before the next court date.
Okay.
If you do, bring the reset notice to them and they'll tell you what you need to do. I'm also ordering as a condition of your probation that you have a drug patch. You need to have a drug patch put on within 24 hours. And you will, probation, when you're walking out, the lady sitting at that desk can give you a list of places where you can get that done. You have to have it on, you wear it 2 weeks, you have to show up every 2 weeks to have it tested. If it's not testable, I'm gonna assume it's positive. If you don't go show up when you're supposed to or go get it, I'm going to assume that you're using something that's illegal. Your bond will be raised and you'll be in jail. Do you understand?
I do.
Okay, so you need to have that on within 24 hours. So by tomorrow, you need to have the drug patch on.
Okay.
And then don't use anything that could potentially test positive for anything. It's that simple. If you're on a probation and you've got a felony pending, you need to be crystal clean, all right?
Like 10 medicines that I'm on.
If you are on medication that shows you to test positive, that's one thing. A gummy from the corner store is not medication, right? So bring your list of medications. If you test positive, show them. We understand. I know what things test positive for other things, but gummies aren't one of them. All right, step in front of the clerk. She'll give you your reset notice.
Make that a condition of her bond, because I can't do anything with her probation in Jasper.
Yeah. It's just a bond here.
Okay, condition of the bond.
Yeah, did I say that the other way?
Yes, ma'am.
Condition of bond.
That's okay, just making sure. And sign it and talk to my lawyer about it. Well,
Mr. Macon, you have Matthew Baxter. Okay, I'll call it as soon as it's ready. What about Patterson? I'll hold those when they're both ready. I'll get you back up here. Thank you. Mr. Let's see, Crenshaw.
It's okay, so whenever it's on the initial, this is how we do it.
Mr. Galmore, you have James Rucker. Morning.
How are you?
Morning. All right, good morning. You're James Rucker?
Yes, ma'am.
All right, where are we?
Judge, we basically completed discovery.
Okay.
We're gonna need a hearing on the motion to quash on one of the indictments. So,
Okay.
We kind of talked about our schedule and the timing. We were asking for 3 weeks, the week of June 16th, whatever day, if that week is okay.
Has it been filed yet?
It's not filed, probably this afternoon though.
Okay.
And they know what it's gonna say. It's gonna say.
That's the week, we're down the week of the 16th.
The week after that. So I'm dealing, will be out for 3 weeks, starting next week, and as a result, I'm covering intake those 3 weeks.
Okay, so just sometime after that, I'll figure out the date.
I am out the next week though. That's the reason.
Just make sure y'all have everything, make sure you've turned in a,
Vacation.
Yes.
I don't know if I have or not. Yes.
if you'll do that, please, that way we can,
Know about it.
well, no, yeah, because if we know about it, then we can reschedule it. So it's much easier for y'all to turn.
What starts as a routine courtroom proceeding quickly turns into a serious examination of an alleged bond violation. Eric Woods Johnson is before the court facing charges that include felonious assault and domestic violence, but the immediate issue is whether he violated conditions of his release. Johnson's attorney tells the court that he is waiving his right to a preliminary examination, and the judge carefully explains what that decision means. The judge makes it clear that by giving up the preliminary exam, Johnson is giving up the opportunity for the prosecution to establish its case at that stage, and he will instead be bound over for further proceedings in Wayne County Circuit Court. Johnson confirms that he understands and that nobody is forcing him to waive that right. But then the tone changes. The judge turns directly to the alleged violation of conditional release. The court explains that a complaint alleging a bond violation can have serious consequences, including the possibility of taking someone into custody when the circumstances support it. However, the judge also makes an important distinction. In this particular situation, police apparently did not personally witness the alleged violation, and the judge questions whether the correct procedure was used. According to the court, when officers do not personally observe the violation and the defendant was not taken into custody, the allegation should be properly presented and supported on the record, rather than automatically treated as grounds for immediate detention. The judge then brings the complaining witness forward and has her sworn in. At first, the testimony is somewhat difficult to follow because there are conflicting dates and details. The witness discusses returning to the residence and seeing Johnson there, while the court repeatedly tries to narrow everything